Now, the Supreme Court will on Monday deliver its judgment on the petitions seeking the annulment of the October 26th repeat presidential election. The court this evening concluded the hearing of the two petitions, with Uhuru Kenyatta's lawyers and Attorney General Professor Githu Muigai defending the move by the IEBC not to conduct fresh nominations. They also dismissed the withdrawal of NASA flag bearer Raila Odinga from the presidential race as insignificant.
It was President Uhuru Kenyatta's turn before the court. His team of lawyers, led by Fred Ngatia and Ahmed Nasir Abdullahi, making submissions against arguments by petitioners former MP Harun Mwau and activists Njonjo Mue and Helef Khalifa.
When you stayed in your house or made a conscious choice not to vote, and you are entitled to, my lord, you cannot question the consequences of a process you did not participate. It becomes a purely academic exercise.
The petitioners want the October 26th repeat presidential poll annulled on grounds of, among other things, failure by the IEBC to conduct nominations of candidates and the presence of violence and intimidation during the repeat poll.
Nowhere in the Constitution is there a provision that under Article 140 sub-Article 3, nominations are required.
No evidence of any person who did not vote because of the violence or intimidation has been presented to this court.
NASA flag bearer Raila Odinga withdrew from the presidential race on the 10th of October, a day before the High Court allowed other presidential candidates to take part in the election. And the lawyers, as well as the Attorney General, who appeared as an interested party, argue Raila's move was inconsequential.
So does the alleged withdrawal of a candidate in a manner, in a procedure not known to law affect the subsequent election? The answer is no. It can't. It can't.
The petitioners are questioning Uhuru Kenyatta's popularity on the basis of a low voter turnout and the postponement of elections in 25 constituencies in 4 counties.
Turnout really is not an argument. In Kenya, there is no compulsory voting mechanism. It's a freedom of choice.
What was the legal effect of the failure to hold an election in 25 constituencies? None. Simple answer. None. Why? Because this constitution does not require majorities based on constituencies. It requires majorities based on counties.
The petitioners raised issues over alleged threats to the judiciary by President Uhuru Kenyatta, the amendment of the electoral laws, and the withdrawal of Raila Odinga's security detail.
It has not been demonstrated how the third respondent's alleged remarks about the judiciary could constitute an election offense.
After the submissions, the lawyers had their final chance to make a rebuttal.
The election that was conducted on 26th was a national presidential election and not a presidential by-election, where it is possible to rule out certain parts of the country.
The petitioners had on Wednesday been granted scrutiny of results transmission forms 34A, 34B, and 34C and the voters' register.
You will see visible alterations to the forms that they themselves have appended. And all of these alterations are to increase the votes of the third respondent in factors of 100 or 200 or 300 per polling station.
The judges now retreat to come up with their judgment ahead of the Monday deadline to deliver it. And all eyes will remain on the Supreme Court, which made history on the 1st of September by nullifying the August 8th presidential election. Rita Tinina, KTN News.